November 21. Dispute involved in this proceedings pertain to eligibility of B.Ed candidates to be appointed as teaching staff in the cases where they did not have D.Ed, which is a diploma course. Rajasthan High Court has held that at the primary level, the eligibility criteria would be D.Ed, DLED qualification, which is a diploma course and not B.Ed. The High Court has quashed the notification of the central government dated 28/6/18, by which B.Ed was included as a qualification for teachers at the primary level from 1 to 5. And in a judgment delivered by this court on 11/8/23, appeal files against the said judgment were dismissed. Now an application has been taken out by the state of MP, labeling it as an application for clarification, and the applicant seeks for us to hold that the said judgment ought to have been prospective application only. Though framed as an application for clarification, it is in the nature of a review petition. Though the application, there is a state of MP, the said dispute is subject matter of a large number of litigation in various states, and we are appraised that in some high courts the matters are pending. Before us, two sets of parties are there. One set wants retention of the said judgment in its present form. The opposing side alleges that it would result in loss of employment to those who were already appointed as teachers in different states on the strength of their B.Ed degrees. It is submitted that they have entered their employment following a legitimate course as per the notification issued by the respective appointing authorities, which did not stipulate B.Ed to be the only requisite qualification. Now, having considered these factors and particularly the contention of the B.Ed applicants that they entered their employment as per the qualification criteria specified by the appointing authority.
Therefore, B.Ed has gone.
B.Ed has gone.
Right.
Till the appointments made
right
till the date of Supreme Court. Let me just come to the last parameter, page 8 minutes. Services of only such candidates.
As it appears, page 7, come to that last one. As it appears that.
Yes, as it appears that a large number of candidates with B.Ed degrees have already been appointed on the basis of eligibility criteria specified by the educational authorities. We do not think it will be equitable to affect their removal. We accordingly hold that on judgment delivered by this bench on 11th August 23 shall have prospective operation, but prospective operation of the judgment shall only be for those candidates who were appointed without any qualification or conditions imposed by any court of law to the effect that their appointments would be subject to the final outcome of the case, which might have been instituted by them, and such candidates were in regular appointment without any disqualification and were appointed in pursuance of a notice of advertisement where B.Ed was stipulated to be a valid qualification. Services of only such candidates shall not be disturbed because of this judgment. We make it clear that this benefit is only for the candidates who were appointed prior to the date of our judgment was delivered on 11th August 23. Mere selection of such candidates or their participation in the process will not entitle them for a benefit under the present order. Moreover, the candidates having B.Ed qualifications whose appointments we are protecting in this judgment will have to undergo a bridge course, and we direct the educational authorities to devise such course, which would be applicable for each state and union territories within a period of 1 year from today. This course shall only be for those appointees who have been engaged with B.Ed degrees only in subject posts under conditions stipulated in earlier part of the order. National Council for Teacher Education shall design such course.
We got it. Yes.
Yes, sir.
Humble submission that I am the intervener in this, and it is to be argued by the senior. I'm humbly kindly this matter after. It is to be argued by the NS. Yeah.
Sorry, who has to argue?
Shri NS.
Madam, listen. You can't misuse like this. And ask Mr. Rupra also. If this court has said he shall not appear, he should not accept any brief of this court. So better you change the advocate and so that court can be assisted. And there should not be any second request on behalf of Mr. Rupra, because there is a judicial order and this court shall not entertain and allow such a request. So nothing is there. I think if something is there.
Yes, bro. I'll demonstrate.
Yes.
Namrod, if the appointments of the B.Ed teachers was subject to qualification as stipulated in this clarificatory order law dated 18/12/2024. This is to be seen. But I have already submitted written submissions of a lot would see and they have been uploaded.
Is there any dispute?
Yes, yeah, in the appointment order, in the advertisement, it was specifically stipulated that all the appointments would be subject to the final outcome of the petitions pending in the High
Right.
Court.
You are a B.Ed?
I am D.Ed.
You are
I am
B.Ed.
representing D.Ed persons. D.Ed. So the all.
ये आप कब से है सर्विस में?
2000
ये B.Ed वाले
मतलब बीएड वाले
23 से
2023
के बाद से इंटरिम ऑर्डर्स उसके पहले के हैं। ये इनके ऑर्डर्स में भी लिखा है, सबके ऑर्डर्स में लिखा है सब्जेक्ट टू द फाइनल आउटकम। सो वो सुप्रीम कोर्ट के क्लैरिफिकेटरी ऑर्डर से कवर्ड है। So there it cannot be said that their appointments are without any qualification. If a lordship, I just not read again paragraph lord. If a lordship would see ये serial number 56 lord.
और मैं
just let me complete this. Plus serial number 56 in the ERP.
Yes.
In the ERP.
Is it serial number 56, Your Lordship?
Sorry?
The synopsis is at serial number 56.
Lord, I read the order which my lord friend was reading, Lord.
yes
firstly that is
Yes.
to be seen how much is to be heard because the matter was decided by this honorable court. Questions were earlier decided by the after Devesh Sharma
Okay.
was decided and this clarificatory order was passed by the Supreme Court that Devesh Sharma will apply prospectively. Thereafter,
Lord, I demonstrate, Lord.
just 1 second. Thereafter, these repetitions were decided by this honorable court in the light of the order passed by the honorable apex court and that clarificatory order that the order is to operate prospectively. Then these petitions were disposed of by the division bench of this honorable court. Then these candidates, some of these D.Ed candidates again went before the Supreme Court saying that this order may be amended because Supreme Court had said that firstly this order will operate prospectively and secondly Supreme Court said that this will the candidates whose appointments are made subject to outcome of the writ petition instituted by them. This was used that instituted by them. Then their appointments will not be protected by this order. Prospective operation will not protect their order. And Supreme Court also said that in case there are some IAs pending before the Honorable High Court, then those IAs should be disposed of. So Supreme Court firstly did not interfere with the order which this Honorable Court had passed while disposing of the writ petition. Secondly, it was the scope was only limited to the IAs which were pending on the date of disposal of the writ petition. Then a writ petition was filed again before the Supreme Court seeking that this word instituted by them should be deleted from the order and it should be instituted by the D.Ed candidates because Supreme Court had said that instituted by them means the D.Ed candidates. If they have instituted the proceeding,
D.Ed candidate.
Supreme Court declined to Supreme Court dismissed that writ petition which was filed seeking that modification. That was declined by the Honorable Apex Court. Now it is to be seen, that the Honorable Court on earlier occasion while disposing of the writ petition had said that B.Ed candidates are not before us because none of the B.Ed candidates had filed any writ petition. Therefore, the court said that their appointment shall remain protected because they are protected by prospective operation. Now they are trying to say that even if the D.Ed candidates had filed a petition and in that there was a direction that appointment will remain subject to outcome, then that should apply to the B.Ed candidate also. That will be contrary to the order passed by the Honorable Apex. We'll just point out to your lordship where the Supreme Court has followed. Please, I am referring to. I have filed a written synopsis wherein I have filed these orders. If I can draw
that advocate mentioned on behalf of Mr. Rupra, she is appealing on behalf of
interveners.
B.Ed candidates.
We all are for B.Ed candidate.
you are
B.Ed candidate.
B.Ed candidate.
Yes.
Okay. That's one. Yes, please. Then non to you are there. That's one. Yes, please.
Can I draw the attention of your lordship to this?
The lordship can take up this matter at 2:30.
2:30 because we have fresh matters. 2:30. Any other day then?
Because this may not get concluded by 1:30. Therefore, I would. Because Lord, at 1:30, Mr.
Any date?
Honorable Justice Adhikari has to visit the Bar Association, Lord, at 1:15.
Okay.
Therefore, Lord, after or tomorrow.
What is? This was 29th, 28, 29,
Blood then 30, then first.
30,
First.
30,
First of May.
okay, first way. First way.
My lord, this matter pertains to compassionate appointment.
Yes, please.